With microphone check. Y'all give me a thumbs up or a like if you can hear me good. We are up and running. We want to make sure that our output is going good. Sounds like we got that. Boom. Oh, why can't I need to turn off my system preferences. Check 1 2, check 1 2. Check 1 2, check 1 2, check. You guys let me know. 10-4, we're still rolling good, so we should still be good streaming. Check microphone 1 2. So we're gonna do this a little old style, cause Dad with the phone is still old school, and I'm gonna call in, and we'll just have him speakerphone in. Should be okay. You guys should be fine. My dad don't want to be on camera anyway. Shoot, I'm lucky to get him on the phone. But just so you can understand, I'm sure y'all figured out who my dad is. He's on the right in the, or on the, I'm lagging now because I'm looking at something else. So let me look here. That's him holding all them drugs right there for sure. And then now he's on the far left. If you're looking at your screen, the far left. And that was the SWAT team that he was the captain over. This, he's the instructor in the back. That's an automatic weapons training that he instructed. And then he's on the far right. And those guys are a part of the SWAT team and helicopter pilots. And then he's in the back. There you go. Y'all figured all that out. We are about to make a phone call. I'm going to go offline for a second just so I can get him prepped to talk. Make sure he ain't doing nothing he ain't supposed to be doing. I'm not going to go offline. I'm just going to take my audio off for a second, and we'll be right back. We're going to kick this off right at 8 o'clock. Share it, like it, go bombard somewhere with it, harass some folks with Dad with the phone. You guys know what to do. You got 5 minutes to share and like this. Get your popcorn. This is probably the foremost expert you've heard from when it comes to a criminal case like this. We'll establish all that in just a little bit. So, go share, like, blow up Facebook, Twitter, Instagram. Go smash this on Andrea Canning's page. Go tweet this to Sam. Go wake him up. we'll make sure they can hear us all. So, hey, we're live. I got my dad on the phone already. Dad, say hello to everybody.
Hello.
I just want to make sure you guys can hear him all right, and I know he's not going to be as clear as me, but Dad, tell me about your background.
Well, I've got 45 years plus experience in law enforcement. I started back in 1970 in the military police, and then went on to the Waco Police Department in Waco, Texas, until the late 80s, and then I went from there into private corporation for a few years, and then back into law enforcement for another 10 years in the Tarrant County Sheriff's Office in Fort Worth, Texas. Retired from there in 2004 and moved to New Mexico, where I took on a job as a narcotics agent with a high-intensity drug trafficking task force out of Alamogordo, New Mexico. Went on to work for the Sheriff's Department for a few years. After about, in 2012, I went to work for the District Attorney's Office as a chief investigator for the 12th Judicial District, which takes in Lincoln and Otero counties here in New Mexico. And in 2017, I retired. Been retired now, into March, it'll be 2 years.
All right, Dad. So in that extensive, my whole life, I've been telling people 30 plus years. So you're saying you've been in law enforcement 40 plus years.
Well, look at I started in 1970, so.
No, there you go. No, I just was wrong. I was just wrong on the dates and times and trying to make sure I get all the date. So we were talking earlier, but about you don't have to give me an exact number. About how many homicide cases, investigations have you been involved with in your law enforcement career?
Well, just in the Waco Police Department, the 13 years I was there, I was involved in over 5,000 cases. Approximately, and this is, I don't have the exact numbers, maybe 100 of those were homicides or suspicious deaths, suicides, that kind of stuff. Then at the Tarrant County Sheriff's Office, I was a captain in the criminal investigation division, and we had a few homicides there too. So I can't give you the exact number.
Say 200 or under or over 200.
Well, it was probably under 200, but not much under.
All right, and then recently you had some experience, and I'm just trying to we're just classifying your experience in this because you had some experience and you got some training with cell phones and cell phone data collection and cell phone tracking, or not recently, but in your last investigation period, you were telling me about this. Can you tell me exactly what that is?
In the last 4 years or 4.5 years with the District Attorney's Office, I received some extensive training from a gentleman who actually taught at the FBI Academy on this subject of analysis of cell phone records and cell phone tracking through the records, and also the science used by cell phone companies to collect their data and what kind of data they can collect and so forth. Now, the science has advanced even further after beyond that. But the information that I received and the training I received was in the last 5 years.
And with the cell phone stuff, how is that being used in courts, and how kind of go through how extensive that is, and how, like, give me an example of when you've seen this used in maybe a court scenario.
Well, for instance, one of the cases that the district attorney's office was in reference to a vehicular homicide that happened in the city of Alamogordo. There was questions on whether the person who ran a red light at an intersection and killed the gentleman was texting at the time that he ran the red light. Of course, he denied it, but through search warrants of his cell phone records, and I was able to make an analysis and track the time period that the accident happened back to where he started receiving text messages and sending text messages from the time he left Rio Dothan, New Mexico, driving down Highway 70 and Highway 54 into Alamogordo, and up to the time that the accident occurred, he was actually receiving a text message just before that and sent a text message about the same time the accident happened. The case never actually went to court. He, when confronted with it, he took a plea bargain and was sentenced there. So that's the kind of thing that we can do. We can, or that can be done, is they can tell which tower the text message went through, the time that it went through, and the direction from the tower that it came, that it was sent out and came into, if it's a text message being sent by the person. Each cell tower has 3 sides, and they can tell from those sides the direction that the signal's coming into or is sent out to.
So they can pinpoint you, how you know, 100 yards, a mile. Can they pinpoint if you're moving? Can they see your movement?
No, they can't necessarily see your movement. I'm sure there's technology now that is advanced to pinpoint it closer, but it is a general direction. In other words, if you know somebody is traveling on a highway and you can see which tower they hit and the direction they hit it from, then drawing a straight line from that side of the tower where it intersects the highway would be an approximate direction or location where it came from. You do that over a period of time using the text message data, and when he's receiving text messages and sending them, then you can track that person down that highway. Not to an exact pinpointed location, but within a general area on that highway.
And these techniques, as far as you've seen them used, are they used to kind of establish timelines and help back up other evidence, or are they used by themselves as evidence?
Well, they're usually used to help corroborate other evidence. Evidence of itself is not necessarily by itself being able to prove guilt or guilt beyond a reasonable doubt, which is what you're trying to do. But you take the whole evidence and look for evidence that corroborates other evidence that you have. For instance, you know, if you want to locate where somebody was at a particular time, if they were using their phone. See, your phone sends out a signal on a periodic basis, depending on the model and make of your phone. That signal hits a cell tower. So when somebody calls you, the cell towers are linked electronically, and so when that call goes out, say from somebody in one side of the United States to somebody in the other side of the United States, because of the links and the periodic positioning that is sent out by your phone, they can be able to know what tower it is that you're near and send that call to you in your phone on that tower. So even though you're not using your phone, as long as it's on then your phone is actually sending out periodic signals to cell towers, especially if you're traveling. If you go from one part of the United States to another, all the way across the United States, when there are cell towers within range, you're going to ping off of those cell towers, showing where at any particular time where your a general area where your phone is.
Gotcha.
So using that, sometimes you can pinpoint that X person was close to somebody's house about the time that that person was assaulted or raped or in your case there, murdered.
Well, you started it when you said my case. Why you got to say my case, Dad? It ain't my case.
Well, the case that you're looking at.
Yeah. Okay, so let's. I have a question to ask, and we can get into a little bit more detail about it. But when it comes to murder and homicide cases, what kind of outcome have you seen when there hasn't been a body?
Well, those kinds of homicide cases are very, very difficult because what you have to have is a great bit more of circumstantial evidence. Circumstantial evidence is basically evidence that doesn't directly tie the person to the victim, but through circumstances shows that he could have very well committed that crime. So you have to have a lot more of that. You have to have a lot more corroboration of evidence that you do, physical evidence that you do have, to try to prove that case. And it's very difficult to prove a circumstantial case. We had a homicide here in Otero County that is full of circumstantial evidence. The problem is that there is not enough corroborating evidence to go with the circumstantial evidence to actually file a criminal case against the person. So that's kind of one of the things that comes up with the case where you don't have a body. A body has a tendency to present a lot more physical evidence to tie someone to that particular crime. Whether it's fingerprints, DNA, fibers, hair, just all kinds of different things that can end up on a body that can help you pinpoint who committed the offense. So it is very difficult, but I have seen it done on occasion where there isn't a body.
So when you say on occasion, you're not saying this is not a normal this is not a normal thing when you go to trial a lot of times for murder. There's some sort of physical evidence is a much better plan than going without one, correct?
Oh, of course. I would say 90% of the time you're going to go you're going to go to trial if you've got a body. 90 to 100% of the time, if you've got a body and you've got a suspect and you've got physical evidence, you're going to go to trial. Without a body, it's a lot more difficult. So the odds of you going to trial without a body is a lot slimmer.
Now, I know that you haven't been, you don't know as much about this case as maybe a lot of the people watching, or even me, just because you told me to send you stuff and I didn't, and I didn't get you all prepared for this, and we just kind of took this off the quick realm. Did you get a chance to look at any of those warrants and stuff that I texted over?
Yes, I did. I looked at one of the affidavits for search warrants, or arrest warrant, an affidavit for an arrest warrant.
So, but you didn't get an extensive look. You just kind of glanced at them?
Well, I just read the affidavit, which is the probable cause that the officer puts down to a judge to substantiate the probable cause to have the arrest warrant issued.
Gotcha. On this case, you did watch the Dateline, though, yeah? You saw me on Dateline?
Yes.
Well, what'd you think?
Well, I think a lot of the physical evidence may not be there. There is some physical evidence, but there is the testimony of this nurse out of Utah or Idaho.
Idaho, KK. We call her KK.
Well, whatever. But that testimony can also be, it has to be corroborated with physical evidence or other testimonies.
Well, let me ask you this: could that testimony? Would you say that testimony could be corroborated through cell phone pings?
Well, some of it, yes. But it's going to have to have more physical evidence, or at least something. And I don't know that much about the case. I don't know how much physical evidence they have to corroborate her statement. Yeah,
we don't have a ton. They do have some blood that was collected after the scene, but I was going to get to that. Let's talk about wellness checks. Have you ever had to do a wellness check on anybody?
Oh yes, several of them.
So, and what do you think? Do you think the wellness check procedures in New Mexico and Texas, do you think they're pretty similar to the wellness check procedures here in Colorado?
Yeah, I'm not familiar with them in Colorado, but it's pretty standardized.
So, a couple of things happen. We don't have to go deep into detail on dates and times and stuff, but at one point there was a wellness check made where a Woodland Park officer walked through the house. Now, in your mind, do you think, or do you have a system in which you follow when you're doing a wellness check, or are you literally only looking for the person?
Well, of course you're looking for the person, but one of the things that you look for is any evidence of that would be out of place, anything that would be out of place. Whether the person's car keys are there, whether the cars are in the driveway, if it's a single person, whether the lady's purse is there, cell phone. I might look in the closet to see if all her clothes, if it appears that she's taken her clothes. Of course, you're going to look for obvious signs of struggle, whether it's broken furniture, broken lamps, turned over furniture, papers strewn around. The obvious things that might be evidence of a burglary or an abduction. And so if there's nothing out of place and there's no one there, of course, I, as the officer, I'm not necessarily familiar with what is supposed to be in place or out of place in that particular house, because I've most likely never been in there. But you can tell whether there's been signs of a struggle. So those are the kinds of things you're looking for.
So
you're not necessarily looking for criminal evidence.
You're not going to necessarily notice if there's a floor mat missing because you've never been there.
Right.
What about okay, and so, and it's possible that if there was a struggle and it was cleaned up, even if it wasn't cleaned up completely, you're not necessarily looking behind stuff, looking for blood or anything like that if there's not obvious blood everywhere.
Well, yeah, you're not necessarily moving furniture, checking drawers or anything like that. You're looking for the obvious, basically what you're looking for.
Okay, at one point in one of these wellness checks, they somehow, or they went in and they changed the passwords on her computer and her social media so that they could see if anybody had been using them. In a normal case, would you need a warrant to do that, or could an officer have permission from the family or someone to say, yeah, do whatever you can, look on her computers, see what you can find out?
Well, That's difficult to say under Colorado law because I'm not familiar with it exactly what they would need. There are some circumstances where, say, the computer belongs to the parents of a girl that's missing, a young girl, a minor, where you can get permission from the parents to do it. This case, I don't know exactly what they did and what procedures they used to get that information. They may have gotten a search warrant or from the judge to look in it. In New Mexico, in this particular kind of case, I would have to get a search warrant because she's an adult. It's her computer. Now, if the computer was on loan to her from, say, her mother gave her permission to use the computer and it belonged to her mother, that might be a different thing. The other thing is, too, they may not have searched the computer using the mother or somebody else in the family may have had the passwords for the computer and given it to them. In that case, it would be some question whether it would be legal to go in the computer or not. But I just know in New Mexico and probably Texas, you're going to have to you get a search warrant for those electronic devices.
Gotcha. Let's. I know you can't speak to the exact plea deal that they gave KK, the girl, the nurse, but when someone admits to coming down and she has admittedly say that she has come down and almost poisoned Kelsey, and then she came down one time and was almost gonna hit her with a beam or a bat or a bar. She tells this story to law enforcement eventually. She doesn't tell them right off the bat, but then she comes in with this pretty elaborate story and pretty detailed story about how Patrick had killed Kelsey and how he enlisted her to help and clean up, and it took her 3 or 4 hours to clean up, and then she takes the cell phone and she goes back to Idaho. She destroys evidence. All of this goes down, and she doesn't spend a day in jail. She doesn't spend a night in jail. And for all intensive purposes, if she completes her deal as laid out, testifies, she may not spend any time in jail. Is this something that's pretty prevalent across the country? Or is this a special circumstance that this girl got this phenomenal, got off on assisting a murder kind of deal?
Plea bargains with potential witnesses that are potentially co-defendants are pretty common. If you want to get them to go on the record to tell the story that can be corroborated, can be verified, to find out exactly what happened. Yes, they're common, and I can't say one way or the other in this particular case if she got a great deal or not. The thing is that she has to fulfill the stipulations of the plea bargain, and if she doesn't, then the sentencing judge or the judge that accepted the plea bargain can make a decision on what he wants to do about it, and also the prosecutor can come back to the court and try to get it changed if she doesn't fulfill it. And then you have sentencing. I don't know what the sentence range for the charge that she is pleading to, but she can get the maximum if the judge feels that it's necessary.
So now, right now she has a possibility of up to, I think, 15 or 18 months in jail, unless they add like what they call an aggravated on top of that, which they left themselves an option to leave an aggravated charge. Then she could get up to 3 years in prison. Now that the story is being told about how involved she was, a lot of people have asked, and also a lot of people have asked, if she lied to get the plea bargain and it comes out in testimony that she lied, as far as if they put her on the stand and they cross-examine her and they push her and she tells a lie, or she gets caught in a lie that she made the deal with, is there a way for the judge to say that deal's no more good, we're going to recharge you? But since the judge has ruled on it and she's literally pled guilty and he's done all the Miranda rights and waived all the appeals rights, can the judge back out on the deal if she's seen to be lying in the deal, even if the story changes in testimony?
Well, a lot of it's up to the prosecutor. If the prosecutor wants to push it with the judge, that's up to him. I'm not familiar so much with the court proceedings of Colorado, and I'm not sure if the judge can back out of it. The only thing he has with him, and a lot of it depends on the prosecutors. The judge doesn't necessarily make the decision on his own to make it null and void. He has to have recommendations from the prosecutor. So if the prosecutors don't push it in her particular case, then the judge usually doesn't try to back out of the situation. He may make a decision in sentencing, which is completely on him. There's recommendations that the prosecutors can make to the judge. Of course, the defense can make recommendations too, and it's up to the judge to make that decision. So I'm not sure if the judge in Colorado can back out of that particular situation.
It doesn't sound real normal for a judge to back out of what he's already ordered.
No, it's rare, but it's not something that doesn't happen.
All right, so you're saying there's a possibility, is what you're saying.
Well, that's the thing in a courtroom. There are certain rules that are bound the judge, bound the prosecutors, bound the defense attorneys, and those rules are set down by the court system in Colorado. In New Mexico, you have the Supreme Court that kind of sets those rules here. In Texas, it's the Texas Court of Appeals that sets those rules for criminal cases. And so those court rules are set down statewide in the state courts, because each state has the ability to set their own rules within reason as far as court procedure. So, I can't speak to Colorado. I'm sorry about that.
I got you. No worries. When how much they read a lot of circumstantial evidence where the mother tells a story about how Patrick freaked out at childbirth and has maybe an anger problem, and they're telling these stories about different things like that. Is that something that when they get on the stand, if they're going to testify, is that stuff that people can speak to, the way someone acts like that, if they've seen them hostile or anything like that?
It's usually not admissible in court. It can be admissible in the sentencing part of a court case. It's usually not admissible in court unless it speaks to actions on the day or around the event itself. I say around the event, say within hours of the event. If somebody acts strangely on the day that this person was killed, that lends credence to the fact that they may have done it, then those are things that can be testified to. Testimony of past actions or past reactions in some cases can be brought forth, but in most cases are kept out of the particular trial itself. So it makes good news on television or in a documentary such as, Dateline, but it also leads credence to, well, this guy's got a temper or he or whatever, but it may not ever end up in court.
Okay, so here's a question. KK makes a deal for, she got her plea deal. She can't get any more than 18 months or what, even if they aggravated 3 years. What happens if Patrick goes to court and is found not guilty of murder? KK still has to fulfill her punishment for the deal that she pled guilty to, even though that isn't a reason why the judge could take her deal away.
No. Once she's pled to it and the judge has ruled on it and accepted it, the fact that another case involving someone else, maybe around the same event, doesn't make it makes no difference. She's still stuck with it.
She's stuck with it, and if her testimony's not enough to convict him, he could go free and she could walk away with almost like a slap on the wrist in this case.
Well, you don't know what the judge is going to say with she may end up in prison for 18 months, or... Yeah,
absolutely she could do that because the judge did not, the prosecuting attorneys did not give recommendation because there is no minimum recommendation for this particular charge, so he doesn't have to give...
The prosecutors are not going to commit to recommendations on her sentencing until they see what she does in court.
Yeah, Gotcha.
Once she's done all of that, then they'll make recommendations. But the strategy is, okay, we've got her to agree to testify. We've made the deal with her, and that's the reason why they got all of her stuff taken care of up front before his trial, so that she's committed. If she goes and changes her testimony, well, that might be enough to change the plea bargain, but it may not. It may be locked in already. So they're going to wait on sentencing to see what she said.
Have you ever dealt with a case where a body has been supposedly burned?
Yes.
Was the body burnt? Does a body burn beyond? Like in that case, or maybe it was different. But the bodies, do they burn? Bone and everything. Or will you still be able to get some evidence from a burned body?
Depends on the method of burning. To cremate a body, which is what happens when a body is, purposely cremated for a funeral, it's going to take about almost 2,000 degrees of concentrated heat to burn flesh, bone, and all of it. There still may be some bone still left in it. So to burn that kind of body that way in just the open air is very difficult. You have to have a confined space. You have to have a heat source that is very strong and constant for a good period of time. So, burning it in a car, say the incidents that I'm familiar with are situations where bodies were burned in a car. you still got quite a bit of body left and quite a bit to identify. That can be identified. A lot of DNA and evidence can be destroyed through burning, but if there is significant bone marrow left in the body, or tissue, or even hair, identification can be made.
Gotcha. And this one's a little tougher question. The story is told that Kelsey was beat to death with a bat, and that it was a pretty bloody, gory, blood spatter everywhere. To get that cleaned up after it was sitting for a day, as the story is told, it would be a little more difficult to clean up. Blood's not the easiest to clean up, and in a bat in your opinion, a bat would be pretty messy.
Yeah, it would be. Any kind of blunt instrument would be messy.
And so that she tells a story of cleaning up this apartment after this murder in about 3 or 4 hours, and cleaning it up enough that that a law enforcement officer during a wellness check didn't notice anything out of place. Does that sound? You've seen a lot of crime scenes. Is it something that could be cleaned up pretty quickly? Or is it really just circumstantial to the actual event?
It depends on the proximity. If it all happened, say, in one small room, like a bathroom, where there wouldn't be a whole lot of stuff in the rest of the house, yeah, it could be cleaned up in 3 hours. I say cleaned up so that you visibly couldn't see anything. That doesn't mean that there wouldn't be any residual evidence. There are chemicals that can be used to be sprayed on areas, and it will show up blood, the presence of blood, because of the proteins in blood that react. Even though the visible blood is cleaned up, there is still some residual unless you use some extreme chemicals, which would not necessarily be available. Now, bleach would be one thing that could be used, but a household bleach many times is diluted enough that it necessarily wouldn't clean all the proteins up that would be visible under some chemical analysis.
When how much blood do you need to prove that there was a murder?
Oh, that's a question. That's a question I can't answer. Because, the defense can say, she cut her finger, and that's how much blood there is. Now, if there's an overwhelming evidence of blood, such in a crime scene where there's blood everywhere, that would be a doctor or a pathologist that would have to testify to the fact that amount of blood would mean that the person couldn't survive. And
so if they just found, but if they just found blood splatter, like some drops of blood up on the ceiling and a few drops of blood or runs of blood, over the toilet, the question is they have some consumptive testing they have to do, and they're going to be testing some DNA and stuff. There is some cross-contamination I talked about with you earlier about when collecting evidence, and you said even though the parents and the brother may have stayed on location after the fact, after the wellness check, before they felt like there was a crime scene there, and the brother and the mom report some blood under the sink or by this toilet, even though they are the ones reporting it, and they're also reporting that, there's a bath mat missing or a special picture or different things, even though they're the ones reporting it after the fact, if police come there and they collect the evidence on location, that's still a pretty good evidence chain.
Yeah, because they'll have to testify to it, and I'm sure what people that first saw it will have to testify to it. But one of the things that messes up a chain of custody is when other people get involved in handling the evidence that aren't law enforcement or aren't in the chain of, or the court's chain of custody. For instance, if they had found something and then taken it to the police department, that would cause a problem with the chain of custody. And now it doesn't mean it wouldn't be admissible in evidence, but it would be challenged when admitted into court, and it would be a big challenge. Now, since they just noticed the evidence and the officers came and collected the evidence at the scene, that establishes a clean chain of custody because they didn't tamper with it. If they tampered with it, then that would break that chain of custody that you need to get it admitted in court.
Gotcha. And then there was some evidence that was collected at a public dump, and they're actually doing a search right now of the Midway landfill. If they find evidence outside of actual physical body pieces and or something that could be tested with DNA, it would be hard to chain that evidence back to this crime since it's gone into a dump and mixed up with different stuff. And can you see any way, shape, or form evidence that was collected at a big landfill being used in a courtroom?
Well, yeah. Say, for instance, you mentioned this floor mat or this bath mat.
Okay.
If this bath mat was found at the dump, and you were able to establish that was the bath mat that this person had, either through evidence on the bath mat itself, then you could admit that to court, admit that as evidence in the case, even though it was at the dump.
Okay, so even though it had, I gotcha. So even though that it was mixed up, if there's a way to chain it back to where it started, or this is the mat, then it could still be used.
You could prove that is the mat. Now, I don't know exactly how you would do that, other than, say, they found hair on the mat that belonged to the victim, or DNA on the mat that belonged to the suspect and the victim, or if there was blood that belonged to the victim on the mat. And there's a good chance there was blood on it because the mat was removed. If there wasn't any blood on the mat, why remove the mat?
Yeah, and a lot of the stuff they collected, or a lot of the stuff that's missing, has been told the story that it was all burned. And I do believe really what they're looking for down at the dump is some sort of remains, pieces of bone, something that is actually physical, physically tied to the body or something, so that they could have some sort of establishment. At least the way that they are explaining the search. They're not necessarily looking for a mat. I just use that as an example because they did.
That's all I did was use an example too. I don't know if they're looking for the mat.
No, yeah, I mean, there's other stuff like they collected something like, I think it was either 35 or 65 other pieces of evidence, and they haven't released what those pieces of evidence are very much. There's a lot of collection of video footage, both from people's homes and from businesses in town. Can you speak? How does that video evidence get logged in and into a court system to be able to be used? In a sense of like,
there has to be verification that the video, either by the person that owned the cameras or some representative, if it's a company that owns the cameras, that these are images from their system. Now, there's a lot of times time date stamps on the video itself, and so that helps verify it. But for instance, if it was video from Walmart or video from Safeway, somebody from Safeway security probably or loss prevention would have to testify that this video is video from their cameras. If it was from a residence, then the person, usually the person who owned the video system at the residence is going to have to testify in court, yes, this is video from my system, and so forth. So now, as far as it gets logged into evidence, it basically gets logged in either on thumb drive or maybe a CD or DVD, and then logged in. They may even, in some cases, I say some cases, I don't know if they did it in this case, but I have seen it done before, where they actually log in the equipment that was used to make the video.
On this one, I'm there. There's a couple of different things. There's some video footage. There's also some still frames from like the Arlo camera system. I know you're familiar with that because you got an Arlo system. And then but they didn't get the actual footage because it was past the free 7-day storage that Arlo provides for its free users. There is
but whoever saved the still footage, whoever saved that still footage, the homeowner saved that still footage. If he saved that still footage and made a regular picture out of it, he's going to have to testify that that's what he did.
Well, the picture that he got is from the still frame alert, that comes to your phone. Sometimes if you have it set up that way, so they got a still frame of some different things. So it's not really the best resolution because it literally is a screen capture off the phone when he got the alert, because it wasn't unusual to see people in this area, and it wasn't like there was a struggle out front. And it was captured, or recorded on the days in question, but it's, again, they haven't necessarily said they have video from Arlo, and I didn't see a warrant, but there were about 6 warrants that they didn't release because they had either come back no return or they hadn't run the warrant. And so I did read in the Arlo security system that the Arlo does possibly save the footage longer than 7 days, and if a court or a warrant, a subpoena is issued or something, they will cooperate with law enforcement. Let's see here. We got about 10 minutes left. You got any questions for me, Dad, and craziness, or you got any questions about this case that maybe give you a little better insight?
Well, like I said, I hadn't read the material yet. I'm going to read the material and go from there. But like I did read the most of the affidavit for the arrest warrant, and I did see quite a bit of circumstantial evidence in there, some direct testimony, and reference to some video, home video evidence of somebody fitting his description being in a location about the time. Actually, I think it was entering this lady's house and leaving her house. So the thing is all the evidence that they have so far is well enough for probable cause to make the arrest. That's obvious. whether that evidence holds up in court will be to the follow-up that they're doing now to obtain more evidence, obtain more testimony, and so forth.
So his next court appearance is what they're calling an arraignment, where he will then plead not guilty, or will have reached some sort of plea agreement, or it will be in the works of a plea agreement. At this, oh, go ahead.
An arraignment basically is he's read the charges and he either pleads guilty or not guilty. Okay? If he needs an attorney, the judge will issue,
Oh, well, we're already down that. I think he had his initial arraignment where he was issued an attorney, and then we've been in this limbo for different motions. Like they filed a motion to do some consumptive testing, but they have now pushed that back because there's an argument over the proper procedure in that testing from the defense. And then there is the court's coming up is that arraignment for that plea. He's already been appointed an attorney. An attorney's been working with him. In a case like this, I guess it's going to be different in each state, but there's some concern that they could push a trial out a year or maybe 2 years. Have you seen that in murder trials like that?
I've seen them go on for 3 years.
Oh, yeah?
The thing is with murder trials, especially first-degree murder trials, which that's obviously what he's charged with according to the arrest warrant, there could be delays by defense, delays by prosecution, motions that have to be heard. I saw several motions in there from that were put on by news agencies trying to get access to information, trying to get access to cameras in the courtroom, so forth and so on. And those things all delay initial trial. Now, they'll set a trial date, and that trial date will probably be as much as a year out. But defense may say, coming up to the end of that trial date, coming up to the trial date, they'll say, we need more time. And so he'll issue a continuance. Or the prosecutor's sick, or the defense attorney's sick, or the defendant's sick. And so they'll issue another date. So, yeah, it's going to get put out. I would be surprised to see this go to trial before 2020, and maybe even later.
So here's another question for you, and I don't even know if you know this or not, but they have at one of at the initial pre-trial, when they were letting all this circumstantial evidence happen, before they started this, they sequestered the witnesses. So like his mother was there, and they said, are you going to testify? And she said, I'm going to plead the fifth. I'm not going to testify. And they said, well, you've been sequestered. You have to leave the courtroom. Then the judge read, is Michael E. Dalton in the courtroom? And he said it a few times. Nikki was actually in the courtroom as it happened. I actually wasn't there by kind of dumb luck, but what would cause, I mean, there's a lot of things I've been involved, droning footage, shooting video, talking with people about the investigation, all of these things I've been doing around town. But would that constitute putting me on a witness list? They called me a state-endorsed witness.
Yes. And the thing is, witnesses are not allowed in the courtroom until their testimony is requested. The state has to give a list of potential witnesses to the defense, and the defense is supposed to give a list of potential witnesses to the state. Those witnesses are barred from the courtroom from that point on.
Well, that's interesting because...
So, and why would they have you as a witness? Because the state believes that maybe they will, maybe, I say maybe, doesn't mean they're going to call you as a witness, that maybe they'll call you as a witness, and because they might call you as a witness about somebody, some statement that you talked to, or possibly because a witness that you talk to, they do want to put on the stand, and if that witness changes their testimony on the stand from what the testimony was that they gave you, they're going to call you as a rebuttal witness.
Okay.
That is testimony. So that's a possibility. There are all kinds of reasons why, but what they will do is they will broaden anybody that they possibly think they're going to call as a witness for any reason, they'll put on that list. And that's why you got put on the list.
Okay, so it is a little unique because although they barred me from the actual pretrial, and they actually may bar me from the arraignment, they let me go to the motion hearing where they
Yeah, but motion hearings depend, unless they're the hearing is in reference to you or something that you did, they don't have to bar you from that.
Okay, yeah. They also let the mom back in and stuff. So it was a little just confusing on a sense of, I know they would have barred me from the court that day, and they would have sequestered me that day, but that doesn't mean...
You're using the wrong term. It's not sequestered, okay? It's a legal term called, they reference the rule. And the rule is you don't let witnesses in the courtroom when other witnesses are testifying. Okay? So to sequester somebody is to mean you put them incognito, separate them.
Gotcha. No, I don't know what the exact term they used in the courtroom, right. But they basically barred everybody that was a witness from when the other, when the other witnesses were testifying, they didn't allow the other ones to be in there. So
and they won't let you do that. And the reason they don't do that is they don't want you sitting there listening to somebody's testimony, and then, well, when I get up to testify, I'm going to interject some of that same stuff. They don't want to taint your testimony versus other people's testimony.
Yeah. No, I understand. Do you think there's any possibility that the state or the defense would put me on a witness list just simply to keep me out of the courtroom?
No, they don't usually do that.
And because they would be pulling the judge into that, right? Because the judge is the one who has to actually...
That's not general practice, and I've never seen anybody do that.
Okay, even a crazy dad with the phone.
Yeah, even a crazy dad with a phone. The thing is, their intention when you put together a witness list, you look at everything that possibly could come up in a case or in a trial that may cause you problems. So you look at the witness list and say, okay, who are people we might possibly call as witnesses? Because what happens is if they call a witness that's not on that list, that person the judge can rule and say, well, you didn't disclose that you were going to call this witness in advance to the defense. Therefore, this witness can't testify. I mean, that's what the judge would say. And so what they're doing is they're broadening the list of possible witnesses. You know, this reporter out of Denver, is his name on the witness list?
Sam? No. Like Sam that's been coming and doing all the tweeting in the court and all that. He's been doing basically the same thing I've been doing, but he ain't been put on the witness list.
Because he's a reporter. And reporters don't have to, people with press credentials don't have to give up their sources of information.
Well, yeah, and the thing is, though, is like I tried to get some press credentials through a press agency, and then they started really hounding that press agency, like, you better not give this guy credentials. And then it turned into it did turn into a thing where they didn't want to give me credentials, because they kept saying it might be a conflict of interest if I'm involved in in this case, this, that, and the other. So,
I don't know why they put you on the list.
Do they have to tell you? Like, if I went and asked them why you put me on the list, would they have to tell me why I was?
They might tell you if you ask them.
But they don't have to?
It's this way. I've been put on so many witness lists and never had to testify on those particular cases, because I called them and I said, hey, why don't you put me on this list? Now, I was a law enforcement officer, or I was the investigator for the DA's office, and my name ended up on the list, and I didn't know why, so I called them and they told me. Now, I don't know if the prosecutor in this case would tell you. They don't have to tell you why you're on the list.
Well, and that's the thing, is like it's okay for the normal person that doesn't want to go to the court case, but for me it's kind of caused me a little issue every time I go over there, because I don't know if I'm going to be asked to leave.
Okay, well, the thing is, you're not going to be able to sit in on the trial. I can tell you that already. Okay?
Were you going to come up here and go inside for me and tweet for me?
I don't even know how to tweet. What are you talking about?
Of course you don't. All right, Dad. Well, you gave me an...
Thing is,
go ahead.
The thing is, they don't know. They don't have to tell you why. But if they do want you to testify, they will get you in and talk to you beforehand and find out what it is they want you to test. You will find out what it is they want you to testify to then.
Yeah, I don't think that's going to happen. I think apportionately, maybe because I got so close to the case and there were some things I said before, maybe, like, I called this thing a homicide before the cops called it a homicide, and was because I got insider information from inside the county, and so.
Well, that's not what they're going to ask you to testify.
No, that's what I'm saying. I think it either has to do. It could go back to that drone footage, because I did shoot a lot of drone footage over some different things that they could ask me just to verify when and that I'm the taker of that drone footage. Right? This could go to they pick up a Facebook.
If they use it in court, you're going to have to testify to what you did.
Okay, so here's a question for you, and we'll finish with this. Omar, or the Mrs. Fraze, she said she's pleading the fifth because they listed her as a witness. Is that even can you do that? Even if
Absolutely.
It's okay, so like even if they call me as a witness, I could just, if they said, "Well, is this your drone footage?" I could just say, "Well, I plead the fifth."
Why would you do that?
You don't know these crazies, so I don't know what they're trying to do. Hey, this is a different law enforcement agency than y'all's little.
Hey, it's the defense you got to worry about if they call you as a witness.
Oh, the defense?
But if the state calls you as a witness, I wouldn't worry about it. They're not concerned with the legality of drone footage or whatever. They're only trying to get it admitted into court as evidence because they want to use it in the prosecution.
Yeah, but they're messing up my content game, Dad.
Your what?
My content game. I can't go into if they don't let me go in and tweet about it. Sam's going to be tweeting about it.
Well, let tweet about it. I don't know.
I got Nikki right here. Don't you worry about Mrs. Underground. She'll be tweeting too. Hey, Dad, we're going to talk some more. I
understand she's already tweeted you. Been in court once.
Oh, yeah, she was in court. She wasn't prepared for that. I sent her to the court on like the most sinister day, and that was the day they talked about all this story that KK tells.
Yeah.
But anyway, I just wanted to say thank you for coming on today. I don't know what our peak was, but we got 180 people watching right now, and lots of people commenting and stuff. And so I just want to say thank you. And yes, I'm going to try to get you on for a second take after the arraignment, after he plea deals or he makes a plea of not guilty or innocent. But thanks, Dad, for spending some time with us on Dad with the Phone.
Okay.
All right. I'll talk to you later.
Okay.
All right.
Bye.
I love you. See ya.
Love you too.
All right. Bye-bye. Well, there you go, kids. Little 60 minutes with Dad with the Phone and Grandpa Underground. I don't know if y'all got anything out of that, or that was the first interview I ever done with my dad on anything, really, I think. So that's pretty good, actually. I thought that was a pretty good interview. Thought that was I don't know if I missed any major. My dad doesn't know everything about the case, so thank you guys. Thank you all the mods. Thank you Jay is for Justice for coming in. Thank you everybody. Christy, I agree with you. I think my dad is maybe missing the term sequestered, because I am pretty sure they use the word term sequestered, but I wasn't going to argue with him. But yeah, that was fun. That was something different. Again, it was a different look. Totally a deal where my dad's qualified in this genre. I really think what they ought to do is we should get one of these big ass corporate networks to pay for me and my dad to go solve some cold cases, and my dad goes about it in the police realm and the in that realm, and then they let Dad with the Phone loose with just his social media chops. So either way, this is better than the Dateline show. I know, right, Stan? Andrea Cannon got nothing. She should have had me and Grandpa on. She should have had an expert on, and then Dad with a Phone, and then she could have done some real good stuff. So, yeah, never argue with the expert, especially when he's your dad. I know. Well, yeah, there's no argument on who my dad is. I definitely look like him for sure. Thank you, everyone. Thanks for all the underground private investigators. I know. See, I didn't get into it, but my dad also is one of the first to do active shooter training, and I really want him to do an active shooter training course and do some stuff with that. But I think he's going to be a regular staple on the Dad with the Phone podcast, underground podcast, because we could just get his take on a lot of things. Catherine Morris, if you're just joining, yeah, my dad is a retired law enforcement agent of over 49 years is what they said. He said 1970 he started as a police officer in the military, as a military cop. So my dad is a law enforcement agent and retired of over 49 years. Federal, state, city, private sector law enforcement, was in charge of the criminal investigations department in a very large Tarrant County, Dallas-Fort Worth area. He retired and was working in the Alamogordo area under a federal drug task force, and then he went to work as a DA investigator in the Alamogordo, Otero County area. So Dad with the badge is correct. I didn't even ask him about Dad with a Gun, but y'all see all those pictures. He's a certified automatic weapons trainer, trained multiple firearms instructor, SWAT team leader for many years, different things. So anyway, I know y'all thought I was full of it when I've been telling y'all I come up in a law enforcement family. That's the law enforcement family I came up with right there. Had to deal. I didn't even get I was going to get the question about the tomatoes when he busted my wife for tomatoes, but we'll get that for another one. So anyway. Oh yeah, he could be a private investigator, but he's retired, man. He don't want to do that. He wants to sit up there and watch the Netflix or something. I'm gonna have to get him out. We'll have to get him out on a case. I think I do have him going to talk at Colorado Crime Con. If you haven't put your application in for Colorado Crime Con, we've got applications coming in. The questions are on Woodland Park, Dadwithaphone, or Woodland Park Underground. You can go find those applications on there. So anyway, that was a fun talk. I was pretty pleased with that. Dad did a strong hour and did pretty good. And then we didn't have no real sit down talk about what we were going to do. We just went after it. So yeah, make this a regular show. Sit down with Grandpa, huh? I know. Everybody wants him. I know what y'all want, see, but he ain't going to get down and dirty and speculatory. He's like, if I want him to actually get into a case, I'm going to have to send him all the discovery. He's going to have to look at all the discovery beforehand, but we're definitely going to get him into the Colorado Crime Con. That was fun. Man, I'm all pumped. Had me a cup of coffee. What's up, Jay? We're going to go all night or what? I got to work tomorrow. Son of a gun. Anyway, that was a fun. Yeah, Colorado Crime Con. That's where you want to email to coloradocrimecon@gmail.com. You want to email your video application. So you want to go check out the list of questions, and you want to do a little video and send us a link to that video. I'm telling you, this is the only way we're going to allow you to go. So if you're like, oh, but so-and-so knows me. Sorry, Jack. I ain't going anywhere to someone I haven't seen their face. So get your stuff together. Do a video. Send it to us. Work. What are you talking about? I know it does sound like work. But it's going to be fun. We got room for about 50 people. Cost is $550 for individuals, $850 for couples or doubles. I didn't even drop any F-bombs while my dad was on. What a good son I am. Work schmirk. I know. Oh, y'all are talking about me going to work. CrimeCon is in comments. I posted it. Sweet. Well, the day after Dateline. You know, I'm just not simply too impressed with the whole. I watched it twice already, and I'm not overly impressed with what Dateline put out. I am happy about Andrea Canning tweeting out there's another part coming, so that's good. ColoradoCrimeCon@gmail, but you're gonna have to get the questions from either this video or post it online, or I don't know, talk to somebody, get a pigeon, a homing pigeon or something. Fireside chat. Turn on the fireside chat, Dad. It's 9 o'clock. It's already warm in here. I'm already warm. The fire is already going. I'm sitting at my desk. Is that Fort Worth in the background of that picture with Dad and two other officers? Absolutely. Yeah, that was where my dad was the head of the SWAT team. That's the SWAT team right there in Tarrant County. And my dad was the captain of the SWAT team in Tarrant County, which is Fort Worth. And so, yeah. I did call her Oma. I was going to call her Oma anyway. But I was trying to say Mrs. Frazee because my dad might not have understood who I was talking about. You said I don't know if my dad called her Oma. Dude, my dad used to be 280. He's 6'6", and at one point he was 280. He's probably not 280 now. He's probably like 240, something like that. Maybe 230. But at one point he was 6'6", 280. That's his meth days. Me and my wife used to tease him and be like, you were sampling the product, Dad, when you were working undercover, because he was working undercover on that federal drug task force. And so he looked like he'd been sampling the product is what it looked like. Oh, badass Texas cop. Yeah, for many, many years, and then he moved over to New Mexico. But yes. All right. Thanks for stopping by, Cheryl T. And I don't know what else we could talk about. I could talk all day. Y'all know me. I could rant about whatever. But I thought that was a pretty good interview. Pretty strong. Ended pretty strong. I should get off here and share it and go make it go viral right now. Yeah, he's a little teddy bear. Just a little teddy bear. No, yeah, I never seen anybody really mess with my dad. Anyway, that was fun. That's a strong win right there for me. Good old interview with the dad. Make him a normal podcast attendee. Once I get this system working, it just ain't working right. Otherwise, he's savvy enough. He could have done a video. Did your dad serve in the military as well? Yeah, my dad started in the military. He was a military cop. So if you go back to the beginning of this podcast, we kick it off and he gives a quick rundown of his professional career. So yeah, just so it's Dad's interview, I would end it, then go live again. All right, I gotta listen to my my internet YouTube coaches. So thank you guys for joining Dad with the Phone Talks to Dad. Dad with the Phone Talks to Dad or Grandpa. And make sure you hit like, subscribe, and all those things you're supposed to do. Thank you, mods, for hanging out. I'll be back. Maybe I'll be back. Maybe I won't be back. But I bet if I do show back up, that you'll show back up. And that'll be fun. Let's go to exactly an hour and 30 minutes. Thank you, ladies and gentlemen, boys and girls, children.